on the slopes of Diamond Head. This is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha and welcome. I'm Ben Carroll. This is Legal Environment of Business, BLAW200. Last time we started to look at the substantive areas of the law. So we started out with torts and we spent quite a bit of time on intentional torts. This time we'll continue on and we'll look at unintentional torts, also called negligence. And we'll look a little bit at strict liability, which involves liability without any fault at all. Okay, well, as we always do, let's start with looking at our review and see what we've seen before. Okay, what is a tort? What distinguishes torts from contracts? Well, contracts, you recall, are voluntary associations, voluntary agreements with people, and I used kind of a shorthand there, and we can call that deals. Okay, torts, on the other hand, are kind of involuntary associations for the most part. So these are instances where we have been injured and we have a civil remedy. And so we can look at those as being duties. We have a duty to act reasonably, and when we don't, we have committed a tort. Okay, what's another word to describe an unintentional tort? And can you be liable if it's not your fault? Okay. These are the two additional areas that we add to intentional torts. So the unintentional, as we discussed, is negligence. So negligence involves something that's an accident, something where you did not intend it, but you are liable because you have been at fault in some way. You have failed in your duty to other folks. And you can be liable even without fault. So there are certain instances where you're going to be potentially liable even if you have been as careful as anybody could be. And you've been even more than what the reasonable person would have done. You've done the most anybody could do. There may be certain instances when you're still going to be liable for that activity. And when we think about that, it's kind of curious. We can be liable even if we didn't do anything wrong. And we'll talk about what that is. But again, that's called absolute liability or strict liability in tort, and we'll be talking about that today. Okay, what is the difference between libel and slander, and what term includes both of these torts? So when we started talking about intentional torts, we looked at libel and slander. And these are both forms of defamation. So these are instances where somebody had said something untrue about someone else that led to some damages. And we distinguish between whether or not that defamation was oral, which we call slander, or whether it's in a writing or a fixed form, such as a recording or on the internet, which we call libel. So they can occur together. And they can also occur separately. So if you're speaking in front of an audience and it's being taped, the oral part of that would be slander, and the recording of it would be libel. So they would occur together. And we've seen this combined pieces of torts when we looked at, for example, assault and battery. Okay, so that leads us to our next thing. Can assault or battery always occur together, or can they occur separately? And what are some of the defenses to this tort? So you recall assault and battery, we say together, we know them as a crime, but these are distinct torts. So what is the assault part? That's putting somebody in fear or apprehension of an immediate harmful contact. And again, the harm doesn't have to be violent or injurious in that sense, but it's an offensive contact. So it's the fear, it's the threat that is the assault. What's the battery? Well, we kind of describe that as the follow-up. So if there's an assault and the person goes through with it and does in fact contact you, that is the battery. Okay. Can they occur separately? Yes, we talked about that. So you can threaten someone and they escape. So they've been put in fear, but again, legs went working and they got out of there. So they did not actually get battered. Can you have a battery without an assault? Yes, somebody can come up behind you, false crack you, hit you from the back. You didn't see it coming, therefore there was not an assault, but there certainly was a battery. And again, it doesn't have to be harmful in the sense of physical injury. It can be offensive, and we'll revisit this when we talk about harassment or something of that kind. What are some of the defenses? Well, consent is an obvious defense. So if you are in a boxing match, you are probably going to get battered. Unless you're pretty quick, you'll get hit a few times. Is that going to be a battery? No, because you've agreed to that. There may be some other instances where you voluntarily enter into a fight and it's not a prize fight, but you have voluntarily decided to duke it out. Okay, so there may be problems with you bringing a battery charge if you've agreed to the activity. Okay, what are some other defenses? Self-defense. If somebody attacks you, then you can strike them back. Again, they're going to look at a reasonable response. So if somebody comes at you with a fist and you use a gun, there may be some issues there. But certainly reasonable response to protect yourself or to protect someone else or even to protect your property if it's reasonable. Now, if you protect your property with some kind of mechanism that shoots people when they open the door, it may be considered that's not a reasonable response to protecting it. But if it is a reasonable response, again, the reasonable person standard, then that would be a defense. Okay. We talked about fraudulent misrepresentation or fraud, and we looked at whether puffery is the same thing as fraud, and we also talked about what's a material fact. So misrepresentation involved making a factual statement, misstatement, so to speak, something that is not true as to a material fact. And what's a material fact? Well, we looked at several instances of things that would be a material fact, and essentially what we're talking about is a fact that a reasonable person would use to make a decision. In other words, it's the basis on which you would decide to buy something or not buy something, do something or not do something, and that would be the material fact. So the examples we used had to do with sometimes the composition, in other words, 100% Kona coffee. You might pay $10, $15 a pound for Kona coffee, but if it's labeled Kona coffee and you're getting the coffee from Juan in Colombia, you're probably not willing to pay that amount. So if you knew that it was not Kona coffee, you wouldn't pay that. That's a material fact. Again, if something's supposed to be dishwasher safe, you put it in the dishwasher, it melts. That's probably the reason you bought it, is because you would rather use your dishwasher than wash by hand. If somebody represents to you that this is dishwasher safe and it isn't, then they have misrepresented a material fact. In other words, a fact that you would base your decision on. We talked about there can be facts that are not material as well. Now, key underlining there is fact. So if somebody expresses an opinion, then a reasonable person would not take that as a basis to buy something or not buy something. And we referred to that as either seller's talk or puffery. And that was the example of the young lady that was trying to sell me a particular brand of deodorant or cologne, and representing to me that it would change my life in some unspecified way. Same thing if somebody indicates that this motorcycle will ride like the wind, whatever the heck that means. That's an opinion. That's not a fact. And a reasonable person wouldn't really base their decision on it. Or so we think. We'll talk about consumer issues when we get there. Obviously, advertisers think that you would use that to base your decision on, but the law has a reasonable person that would not. Okay, we talked about damages, what kind of damages we would get in a tort action, and we finished up with what's an injunction. So what kind of damages do we get, and what do we mean by damages? Damages are the monetary result that we get, and that's how we compensate the person that's been injured. So we try and get them back to how they were. Again, recognizing, as we've mentioned several times, money is the best we can do. Certainly doesn't bring anybody back or bring back lost limbs or anything else, but that's the best we can do in our system. And we have compensatory damages, which compensate the victim, the person that's been harmed. And we have two types of those. So we have the easy to calculate kind of fixed cost kinds of things, like if we've been hurt, our doctor bills, we've lost time from work, we have lost wages, we have some specific things that we know what the cost is, what it costs to reimburse for that. And then we have general damages, which are for the more arcane types of things that happen to us. We won't be able to play volleyball anymore. We won't be able to dance. We can't hike. We can't do this or that. We've lost sight. Those sorts of things. Pain and suffering. So those sorts of things, the fact finder, generally the jury, would put a value on that. Again, very hard, harder than our special damages, but they would give us a value for what we've lost. And those two things we put together are compensatory damages. We also talked briefly about punitive damages, punishing the defendant or wrongdoer or tortfeasor because they've done something very egregious, something outrageous, and in a sense, we're going to make an example of them so that other people won't do that, and so they won't do it again either. So if somebody's made an economic choice that they know is going to harm people, harm the public, then many times the jury, the fact finder, will decide you need to be taught a lesson here, and we will do that by awarding money against you. And then finally we talked about nominal damages, and those are damages in name only, and that's where we give somebody $1 because they have been, for example, defamed, and even though we don't have an actual loss there, we give them the $1 so that they win and so they can be vindicated and say, I was defamed, that was untrue, you shouldn't have said that. Okay. Now, in addition to monetary damages, and that's the bulk of what the tort system operates on, there is the possibility that the court will need to order someone to do something or not do something. And that's our injunctive relief. And that's where the court, for example, may say, you cannot publish that because that's going to defame and harm somebody, so we are going to prevent publication in advance. So our injunctive relief typically is to prevent harm from happening rather than wait and allow it to happen and then try and compensate it later. So certain things, if somebody's in danger of being hurt or damaged in a way that money won't fix, that would be where injunctive relief would be particularly useful for us. Okay, well, let's see what we're going to handle today. We're going to be looking at negligence, and we will look at the elements and defenses as we did with intentional torts. We'll revisit a little bit who the reasonable person is with respect to negligence. Then we'll talk about strict liability, and again, this is the absolute liability that does not involve negligence or fault. And finally, we'll talk very briefly about products liability, and we'll talk about tort reform, and we'll have some other folks join us to have a discussion about those two aspects, the products liability and the tort reform. Okay, so what is negligence? We've already described that as being unintentional tort. So this is something we don't intend. We tend to think of it as an accident. And so this is a failure to exercise the amount of care that a reasonable person would in these same circumstances. So whatever situation we're in, what would a reasonable person, our hypothetical, attentive, careful, honest person, what would they do in these particular circumstances? So, of course, there may be variations in the ability of a person to do something, and there may be variations in what the circumstances are, and we'll be looking at that as well. Okay, to prove negligence, in other words, to be actionable, to have an effective negligence case, we have to have four things: a duty to a person, a breach of the duty, causation, and harm or injury. So if we have these four things, we have what we call actionable negligence. That is, negligence that will be successful if we can prove these. So we'll look at each of these briefly. Okay, so duty is established by the law, applicable to all persons. And again, remember we said duty is a kind of a shorthand for the tort. We have duty to exercise reasonable care when we deal with others. And the different types of torts we've already noted: intentional, careless, or dangerous activities. And it can be both doing something or not doing something. So it can be commission or omission. In other words, if a reasonable person would do something we don't, we could be liable. If a reasonable person wouldn't do this kind of activity and we did, we can be liable. Okay, so breach of duty. What do we mean by breach? Well, we'll use this term again actually when we get to contracts, but breach simply means that we have failed in our duty. So this is a failure or this is fault. And this is where we get the idea that negligence equals fault. So breach of duty is failing to do what a reasonable person would do. Okay, this is a society's judgment on how people should act, what they should do. And as mentioned briefly, this depends on the circumstances. In other words, it's what a reasonable person would do in the same or similar circumstances. And we do treat certain people differently. So we'll look at if somebody has particular expertise or experience, etc., they may be held to a higher duty or a higher standard than an ordinary reasonable person. Okay, causation. And this is a complicated area of the law. There's certainly additional material on causation that we'll look at. But causation simply means that what you did causes the injury to a person. So there's actual causation, and that means that except for this action that you did or didn't do, the harm would not have occurred. And it's what we call proximate cause. And proximate cause, sometimes referred to as legal cause, and that's saying that there's a sufficient connection between the injury and the act that the law believes there should be liability. And to do this, we look at whether it's foreseeable. In other words, whether you could foresee that your action could lead to this particular kind of harm. And finally, a harm or injury. So needs to be something the law recognizes and some loss suffered. So we saw in intentional tort, sometimes we didn't actually need to prove a loss. In other words, we assumed a loss. But normally on the negligence side, we need to show that there has some harm has been suffered. And if you think about an easy example, if you're driving along and you are not paying attention, so you have a duty to be attentive when you're driving, you're failing in that duty because you have or messing with your cell phone or whatever. Certainly you've got two of the elements, but unless you actually harm somebody, unless you hit them, in a sense you're negligent, but your negligence is not actionable because you haven't caused anybody any harm. Okay, we want to revisit a little bit our reasonable person. Okay, so as indicated, the reasonable person standard is meant to be objective and it's meant to be apply to all aspects as much as we can, but there are some exceptions or differences in people we do take into account. So one of those would be physical impairment. So you are only able to do as well as your physical ability allows you. So certainly if you are mobility impaired and can't get out of the way of something, that would be taken into account. If your vision is poor, you do the best you can with that. Now, what's interesting is we don't take mental ability or disability into account. So interestingly, we would hold somebody that is not as mentally sharp, but has either physical issues that affect their mental ability or mental illness or something else, and we really don't give them a break. We kind of hold them to the same standard, even though we give a break, so to speak, to physical disability. So rather interesting area of the law. But we do give minors a break. In other words, we treat minors as someone else of that age. We'll look at that in a minute. So we do take their status into account. And finally, as indicated, we will deal with professionals, experts in a different fashion. Okay, so a minor is not held to the same standard as an adult. Minor is held to the same standard of a minor of similar maturity, capacity, and intelligence, again, under similar circumstances. So the law does consider that people of a certain age, 6 or 7, below that they cannot be liable. Between that, they would be compared in this fashion with other people of similar age, etc. So we do consider minors, their abilities differently from adults. Okay, it was indicated on the other end of that would be the professionals. So a person with particular expertise or competence is judged against other professionals in that particular profession. So if we are having an operation by a surgeon, we don't want our surgeon to operate as a reasonable person would. In other words, somebody we got off the street. We want our surgeon to operate as a reasonable surgeon would. And we may even pin that down to a surgeon of a certain kind, certain type. So we're looking for that much higher standard. Again, we're relying on their expertise, their ability. And we'll look at this. This is kind of a general axiom or theme of the law as well, is if somebody has particular expertise or ability or skill, we may hold them to a higher standard. And we will see this again when we talk about merchants, in other words, experts in sales, that sort of thing. We will see a higher standard if somebody represents themselves as being part of a profession or having a certain degree of expertise and skill. We will hold them to a higher standard. Now, if we have professional negligence, we could simply call it professional negligence, but frequently we call it malpractice. So you're familiar with the terms of medical malpractice, legal malpractice, and we even hear of accounting malpractice as well. So when we talk about malpractice, really all we're saying is professional negligence, just another word for professional negligence. But using that word does kind of highlight for us we are raising kind of the bar. We are requiring that they act as a reasonable professional rather than just a reasonable person. Now, we said that reasonable we keep talking about under the same or similar circumstances, and sometimes there may be circumstances that we will take into account as well. So certainly there's some there's an emergency doctrine which says if we are operating under, so to speak, duress, if we're operating under a situation where we've got to make snap decisions, we may not be acting in the same way that we would if we had time to consider all the possibilities. So we're going to look at somebody that's put into a situation where they have to react quickly, and we may give them a break in that sense that we're not going to totally second-guess you after the fact and apply the same standard as if you had plenty of time to look at all the options and make certain decisions and check things out, etc. If you're under this emergency situation, then we're going to look at that as being perhaps adjusting, so to speak, what a reasonable person would do. Again, we're going to be looking for a reasonable person, but it's a reasonable person how they would act in that particular situation. Okay, so we've talked about the elements, what we need to prove to negligence, and so we'll look at some of the defenses as well, and this is similar to what we did with intentional torts. So we'll look at assumption of risk, contributory or comparative negligence, last clear chance, and superseding or intervening causes. Okay, so what do we mean by assumption of risk? Well, assumption of risk means we assume the risk of that particular activity if the risk is inherent in the activity. So what does that look like? Well, if we're going to go skydiving, we know that when we jump out of the airplane, it's possible that the weather and wind may change, and despite the best attempts of everybody, it's very possible you might get blown one direction or the other, and since we're on an island, you might get blown out to sea, so there's some issues there. If the risk is inherent in the activity, in other words, no matter how careful you are, that risk is part of the activity, then by doing that activity, you are held to have assumed that risk. So that would mean if this thing happens that's always a possibility in the activity, then you may not be able to sue the person that oversaw the activity. Okay. Same thing might be if you're scuba diving. What are some of the risks that are inherent, in other words, a natural and necessary part of that activity? Well, you're in the water, there's some beasties there, sharks, there's a possibility of currents that are unknown, etc. These are things that are part of the activity. In fact, of course, many activities in today's extreme sports kind of thing, the risk is actually why people are doing those activities. Okay. Now, does this mean that if you go on a skydive, parachute jump, and they have negligently forgot to put your parachute in or packed it wrong and you are injured or killed, that you don't have any claim? No, because you don't assume that risk. You don't assume the risk of negligence. You're assuming the risk of something inherent that's a natural part of the activity. So that's what we mean by assumption of risk. Okay, when we're talking about contributory negligence, this is negligence contributed by or on the part of the injured person, the plaintiff. So in addition to the defendant doing something that causes injury, you may have done something yourself that contributes to the injury. So to the extent that you have been a cause of your own injury, the law takes that into account. Now, under common law, if you contribute at all to your injury, in other words, if there is 1% contributory negligence, mostly the fault of one or more defendants, but you had done something that added to or increased or caused your injury, then you might lose your entire case. In other words, if you were at all at fault, you were out. Okay, that has been changed for the most part by what we call comparative negligence. Even though we may hear the term contributory negligence, in many states, including Hawaii, we have changed that to comparative negligence. So what do we mean by comparative negligence? Well, we are comparing the negligence of the plaintiff with the negligence of the defendants. And there's what we call the 50% rule, which means that we're okay as long as our negligence is not more than the other folks, the defendants, the tortfeasors, or the wrongdoers. So if we have contributed to our own injury, we have done something negligent that was a partial cause of our injury, and the other side did something that contributed the other half, as long as our own negligence is not more than the negligence of the other people, we can recover that portion of the negligence. Now, we don't get paid for what we did to ourselves, but we can recover from the other side. We can recover their negligence, what they've done. Okay, there are some special doctrines that are involved in negligence, and so we'll take a look at those and just run through them quickly. We have res ipsa loquitur. That's Latin, so we're going to need to figure out what that means in real English. There's negligence per se, danger invites rescue, good Samaritan for you religious scholars, dram shop acts, and some jurisdictions have something called host liability, which is similar to dram shop. We do not have that in Hawaii. So we'll take a quick look at these special negligence doctrines. Okay, so res ipsa loquitur. Well, this means the thing speaks for itself, and so defendant is involved in a situation, in control of a situation, and injury happens, which would not happen in the absence of negligence. So we've got a little lawyer here, and he will explain res ipsa loquitur, and again, in English, that means the thing speaks for itself. And what does that mean? It means that we have an injury, the defendant is in control of the instrumentalities or the activity or whatever, and we know that there would not be an injury unless something's gone wrong, someone has been at fault. So we may not be able to prove exactly what the negligent act was, when it happened, etc., but the law says we know that negligence is in there, and so we're going to have liability attached. This might happen in, say, a medical procedure. You go in to have something operated on, and something close by is damaged. And it's clear that the damage wasn't there already. It's been damaged in the procedure. We don't know exactly how it happened, what the mechanism was, what the actual problem was, but we do know that this is something that wouldn't have happened unless somebody was negligent, and we know who was doing the operation. So this might be a situation where res ipsa loquitur would occur, and we don't have to show the actual negligent act because it's assumed because of both control and a result that would not have happened without negligence. Okay, negligence per se. Per se essentially means on the face of it, and when we're talking about negligence per se, we're talking about a statutory duty. Okay, so violation of this duty, violation of this statute has caused the injury. Again, a couple things we need to look at when we talk about negligent per se is the people protected, the reason for the statute, who it is meant to protect, includes the plaintiff. So if we have a driving statute that says you need to be this far away from the car in front of you, that's meant to protect the car in front of you. And it also the statute needs to protect us from the kind of injury or the kind of damage that occurs. So the reason we have that is so that you won't run into the back of the car in front of you. So if you violate that and you cause your injury, it's possible for the court to say this is negligent per se. In other words, we don't need to show exactly what a reasonable person would do because the statute tells us this is what reasonable people should do. You have not done that. We do not need to look farther to determine whether or not you're liable. You are because you have violated a statute. Statute was meant to prevent what happened. It was meant to protect the person that was injured, so you have negligence per se. We have a doctrine called danger invites rescue, which is kind of a word picture of what happens. What this means is that it's foreseeable that a person will try to extricate themselves from a danger, or that they will try and hurt somebody else, help somebody else. And so if we are put in a situation where we have to this is sort of like the emergency thing, we're put in a situation where somebody's act causes us to get into harm's way, then any injuries resulting from those defensive actions, from those actions we took in response to the danger, to the emergency, may be attributable to the person who actually caused the danger. So even though it's our activities that have led to injury, we were put in that position by what someone else did. And so it may be that they are going to be responsible for that because they have caused the emergency, they have caused the danger. Okay, the Good Samaritan statute. So, again, your biblical scholars may recall that this is a Bible story where someone was traveling and was set upon by bandits or thieves or whatever and was hurt, and someone else came by, a Samaritan, who stopped to render aid to help them. So we call it Good Samaritan, and we're talking about if a person stops and renders emergency first aid, then that person will not be liable for ordinary negligence. Okay, we do have something called gross negligence. In other words, you do something way out of line that a reasonable person would not have done. Everybody knows you don't do this, and you did it anyway, or you do something wanton or reckless, then you could be liable. But for ordinary trying to help, even if you do a bad job, in other words, you're not very good at your help, and you increase an injury or cause an injury, you are protected because society is determined we want people to help other people. Okay? Now, do you have a duty to help other people? Most instances you would not. So you do not have a duty to intervene to help someone who appears to need help. But if you do, you could be liable except for the Good Samaritan statute. So the Good Samaritan statute protects you if in good faith you attempt to render aid to someone. Now, that's the Hawaii statute. Other places, the Good Samaritan statutes can differ. Some of them apply to medical personnel. They wouldn't apply to people who try and render CPR and they're not trained, so it can differ. But that's what our statute looks like, and it's fairly common. Okay, we have the Dram Shop Act. And a dram shop is an ancient term for some place that sells liquor, and the Hawaii law applies to liquor licensees. So what we're saying is that if you provide liquor to someone who should not have liquor because they are already drunk, already obviously intoxicated, then you may be responsible for serving them, increasing their intoxication if they go on and damage somebody. So again, this is liability even though you're not the one who ran your car into somebody. It was a drunk driver that ran into somebody. But why are they drunk? Partly they're drunk because you served them when they shouldn't have been served. So you increase that, and you may be responsible for serving the alcohol or whatever to somebody who then goes and damages someone else. Okay, so remember we talked about vicarious liability, and in a sense that's a little similar. But it's because you have negligently served somebody, and we are saying that you are now responsible, not just to the person you served, you're responsible to somebody that's injured by them. Okay. Now, we don't have it in Hawaii, but there are some places have host liability, which would mean that a private person might be responsible as well. But dram shop refers to people who are in the business of selling. Okay, we'll talk a little bit about strict liability. Again, we're moving from negligence, which is fault-based. We're moving to strict liability or absolute liability, and this is liability without fault. So that's the critical thing. We're moving from negligence, where we're talking about fault, failure. We're moving to strict liability, which is liability without fault. And again, when we first look at this, we say, that seems a little harsh. Why are we having somebody liable when they do the best job anybody could do? They've acted not only reasonably, they've acted with the utmost care. They've done everything anybody could humanly do, and yet damage and injuries occur from this activity, and we're going to hold them liable. So what is that all about? Well, it's actually a determination that certain kinds of activities are going to put the public at risk. And since the public's at risk, the public needs some way of being protected from the damages and injuries that can happen. So this, again, is a determination that, in a sense, spreading the risk because these activities are likely to and do cause injuries, and we want to compensate the people that are damaged. Okay. So common law attached this kind of liability, this strict liability, this liability without fault, to certain kinds of activities. Okay, again, doesn't require fault, intent, or breach of duty. And the common law applied these to what we call abnormally dangerous activities. And this involved wild animals. So if you have a lion or tiger as a pet, it doesn't matter how careful you do that. So you can pin them up, you can have to take whatever steps you can, but if you have a wild animal, then you may be liable for the injuries they cause. A person would not have to prove that you were negligent. Now, actually, in some states, this is attached to other dangerous animals that are not wild. So you may, in fact, attach this to certain breeds of dogs, for example, which are obviously considered to be domesticated rather than wild. So you might apply this to dangerous animals. And we have not done that in Hawaii, but some states have. And that's, again, because that's considered to be a dangerous, either a dangerous breed or a dangerous type of animal. The other thing that common law typically applied this to was explosives. So no matter how carefully you handle explosives, there's a serious possibility that people will be damaged. So we will look at explosives, and that will be our issue with that. Okay, this has now been extended to products liability. Other things have been added. If you have flammable liquids, if you have nuclear power, etc., these things are also considered to be abnormally dangerous and would be covered by strict liability. But the major area is products liability, and we're going to just talk very briefly about products liability. So products liability does apply to manufacturers of products. Okay, so we'll be looking at that down the road. Just wanted to give you kind of a quick check on it. Products liability can be based on negligence, strict liability we just talked about, and warranty, which is implied promises. And really the warranty is why we will be revisiting this, because warranty is in essence a contractual relationship based on being a seller and a buyer. And so we'll look at that after we've had a chance to look at contract and warranty. So we'll come back and look at that. But products liability talks again about being unreasonably dangerous due to defects, failure to warn, etc. So it includes strict liability, although products liability, again, you can be negligent in your manufacture, and so there are a number of different bases that you can base a products liability suit on. Just want to briefly touch on tort reform. So, you've heard this term probably. What exactly is tort reform? It comes up every few years. It very typically comes up when we're talking about medical malpractice. So you'll hear of doctors have problems with their insurance. Manufacturers are having trouble being competitive because they're afraid of punitive damages and lawsuits, that sort of thing. So we'll talk to some folks and get an idea of what tort reform is all about, what the claims are that it's needed, and whether or not there is a real crisis of some kind. Again, this is kind of cyclical, comes up now and then, but fairly frequently. And so we'll look at kind of both sides of that and see what impact it has on us. And we'll talk about some of the changes that have been a result of various tort reform movements, and some of those have been implemented in Hawaii. There's certainly talk about implementing them federally, which is much harder, but many states have implemented various types of tort reform measures, and we'll look at those. So what we'd like to do is we'd like to talk to some folks that are actually involved in this, so some attorneys that are familiar with negligence work, products liability, and can also tell us a little bit about tort reform, and so give us some perspectives on that will be helpful to us in seeing what this is all about. Okay, so let's go meet some folks. Aloha, we're here with Bruce Sherman. We're going to talk about tort reform. I've worked with Bruce on a complicated case before, but we hope he'll make tort reform a little simpler. Can you tell us a little bit about your background, Bruce?
Sure, thanks, Ben. I do mostly litigation, and the majority of it is in federal court. The types of cases I do are civil rights actions, disabilities actions, employment, and some class actions. Right now, I'm involved in I'm co-counsel for the class in the UH data breach lawsuit. Oh, that's a good question, because I'm not sure everybody is on the same page as to what we mean by tort reform. I think you have to look at the various groups that are involved, and you have to look at what each group advocates and determine what their real agenda is. And when I say groups, on one side you have what are referred to as trial attorneys, or trial lawyers, and these are the plaintiff's lawyers. And certainly they have an agenda. On the other side, you have large entities like the U.S. Chamber of Commerce, and they pour millions of dollars into advancing their agenda with respect to tort reform. But I'm not sure they're always, on the same page. Neither group tends to want to enter or be able to, I guess, enter into a real dialogue. Mostly they just speak at each other, and they rely on buzzwords. And so I think that's what makes it difficult to say exactly what tort reform is. It's something different to everyone. Well, the trial lawyers, for the most part, seem to want to keep things as they are. The United States Chamber of Commerce, if you took their agenda to its logical conclusion, it seems like they would want to get rid of entirely any kind of tort litigation and insulate companies from any kind of responsibility. Now, that's a simplistic statement about it, but they talk about a lot of things, and it ranges from personal injury lawsuits to medical malpractice, and so there are a lot of different groups involved, and when I say the United States Chamber of Commerce, they're not the only one on that side of the issue.
Okay, so basically we're looking at the people bringing a lawsuit for having been injured, in other words, the tort, and we're looking at the people responding, the defendants that don't want to be sued, so to speak, as some of the major parties.
Well, they seem not to want to be sued. I think you need to start at the basic premise. Why do you have a tort system? And it's simple, and that is, there are two parts to it. One is to compensate the victim, and the other is to deter that type of action by the defendant or other party in the future. It seems pretty simple, and yet we seem to have made it very complicated. Well, start off with they don't seem to think much is right with it. But be that as it may, some of the things you hear from Chamber of Commerce and its allies are, we need to have predictability. We can't have runaway juries. We can't have a tort lottery where attorneys on the part of plaintiffs try to ring up a judgment. It's huge, and we can't predict it. On the other hand, the other side, the trial lawyers will say it's just that unpredictability that will keep businesses honest, that will keep them from, and one area we didn't talk about was products liability. It will keep companies honest if they don't know, what they may be subject to if they put out a bad product or a dangerous product. And one of the examples that's used oftentimes is the Ford Pinto case, where supposedly for $11 Ford could have ensured that had done a recall of all the Pintos and ensured that the gas tank wouldn't necessarily explode when the Ford Pinto was hit in the rear. And the story goes that they actually did a business calculation and decision based on actuarial tables that estimated that each case like that, where there was a death or serious injury, would cost them about $220,000. This was back maybe 15 or 20 years ago. And that even if you had 200 cases like that, it would still cost you less than to make the $11 change on each Ford Pinto. Now, I can't imagine any business would want to admit that that's the kind of calculation today they'd make. I mean, it's irresponsible and it's contrary to what we expect of corporations in this society. Well, imagine if you were able to put that in front of a jury, what would happen? I think, while we're talking about these cases, and the cases that are used as examples are almost, I call them now urban legends. And one of the cases, everybody is aware of is Libex versus McDonald's restaurants. But everybody knows it as the coffee case. It's used by a lot of the tort reformers as an example of what is wrong. Unfortunately, they don't tell the rest of the story. And basically, there was an award of punitive damages, but that was premised in part because McDonald's, for about a 10-year period, had over 700 reported coffee spill incidents. And the real problem was they heated their coffee and kept it at 185 degrees. And so if it did spill, it was going to cause third-degree burns. It was a $2.7 million punitive damages award, but it was reduced by the court to about $480,000, which is another safety fact or fail-safe system in the judicial system. Judges can reduce awards, and they oftentimes do to even it out. So people, you need to take a look and be critical when you hear one of these urban legends. And again, as we spoke about earlier, you look at the agenda of the group that's telling you the story. Like in everything, you should be somewhat skeptical. We used to say back in the 60s, question authority. And I think you've got to take that approach here, whether it's from trial attorneys or from the Chamber of Commerce or those groups. Well, let me give you a statistic. In 2007, one report found that medical malpractice cases cost about $30.7 billion. And that included payouts and insurance defense, etc. That seems like an incredible figure. Understand the American medical industry, so to speak, the cost per year is $2 trillion. So if you do the math, $30.7 billion comes to about 1 to 1.5% of the cost of American medical care. The other thing about medical malpractice is that no one brings what is called a frivolous case because they're just too expensive to do. And in fact, I've read that if the tort reformers were really serious about this, they would address the issue where a number of smaller damages medical malpractice cases can't be brought because it's too expensive to litigate them, I don't hear anything about that. It's terribly expensive, and both sides have experts, and then you have experts to support the experts, and that doesn't even count the cost of depositions and other testimony. So it isn't only serious cases are brought. That's a problem. But it's, when I hear the word frivolous lawsuit, I sort of turn off. I mean, there are a number of things in the judicial system that are intended to prevent that. Lawyers can be sanctioned if it's a frivolous lawsuit. But I don't imagine many lawyers do medical malpractice cases on a whim and that are frivolous. These are cases where there were serious consequences for the patients. Well, there's one of those proposals that I could agree with if it were slightly modified, and it has to do with punitive damages. And the complaint, again, by the tort reform group is that trial lawyers make, obscene amounts of money off of these cases. And that's not exactly correct all the time, given the amount of work and risk put into them. But with respect to the issue of punitive damages, they certainly, should have a deterrent effect when they're warranted. But what you could do, and this should, I would hope, mollify the Chamber of Commerce. It takes the trial lawyer windfall possibility out of the equation. What you could do is have the punitive damages given over to the state. Some sort of cy-pray, which is a fancy word for, having the state allocate some trust or other monies to a particular group or cause. Well, that's an interesting question. But to put it in some perspective, understand that the insurance companies, who have certainly lobbied for this, reducing their exposure, every time they've said, understand, this doesn't guarantee or ensure that your premiums will go down. So if you start from that premise, it's not a question necessarily of, the effect these caps have. I mean, they deter some cases, but again, they're cases that should be brought.
Aloha. Well, I hope that was useful to you, talking to some people that are kind of in the trenches, have an idea now about some of the issues that are involved in products liability, tort reform. And there's a lot more material on the website on this. Again, it's a very active area, very controversial. So do look at the materials that are on the website. So go to the Lau Lima site. You'll see quite a bit of additional material on torts, on tort reform, etc. We'll have some discussion about that as well. So kind of put that all in perspective. Okay, well, that was a long session. We have now gotten through negligence. So we've gotten through the fault area. We've gotten through strict liability. So we're going to look at just a couple remaining areas of torts. And we're going to look at intellectual property. So this is a very active area. We've made some references to the internet. And so patents, trademarks, copyright, very interesting area. So please take a look at those materials, and we'll deal with that in our next session. So aloha, this has been Carol. See you next time, BLAW200.